episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime. Tonight, no exception to the rule. We are going to dive right in to the mess that is the Adelsons. There was a obvious bombshell. I think that's an appropriate use of the news cliche. In the 2014 murder-for-hire killing of Dan Markel, as it went off the rails on the first day of jury selection. Steve Cohn and I were up there to witness it firsthand. Dan Rashbaum basically was conflicted out of the case, and then Donna tried to get a new set of attorneys, and Judge Stephen Everett was having none of it. So now she has a pair of Tallahassee-based lawyers. We're going to talk to Stephen Webster, Louis Baptiste, and Joe Patuto about all of this. Professor Joe Patuto, she is the Richard H. Larson Professor of Constitutional Law, Emerita at the University of Nebraska College of Law. She's taught at North Carolina, Chapel Hill, Oregon, Arizona, Rutgers, Seton Hall, and Cardozo. And then you've got the dynamic duo that is Stephen Webster and Louis Baptiste. They are the lawyers behind Webster and Baptiste, attorneys at law in Tallahassee. Stephen was Dan Markel's post-divorce attorney. Louis was Dan Markel's law student at FSU. So we've got all the bases covered. A couple of things I just want to bring up before we get cracking here. This is one. And shout out to the COE for building the graphics for the show. Ruth Markel is going to be back in South Florida. This happened last year around the same time. But if you missed it, it's a really unique chance to hear her speak. And Dave Arenberg as well, who is the Florida state attorney out of Palm Beach County. So that will be interesting. I'll be moderating, and the mods will be putting up a link to it in the chat. So you do have to RSVP, and Ruth is hoping to see many of you there, as am I. And I'll give you reminders as we move forward. Next up, before we get into it, a couple of announcements going on today. This book talk with Carmela and Joel Waldman. This is being sponsored, if you see on the upper left-hand corner, by the Simon Wiesenthal Center in Toronto, Canada. Their Simon Wiesenthal, the center, does a lot of work on Holocaust education. They asked Carm and myself to come on. It is a virtual event. It is not in person. It's a virtual event, and all are invited. All you have to do is RSVP, I believe, and that link will be in the chat as well. So hope to see you there. It's going to be, you get some good insight from Carm, especially with what's going on in the world right now. She's got a lot to say, and I think that's why they invited us. And so we will be doing all that tomorrow. So those are the official announcements. And then we've got a little something at the end of the show that we will fill you in on. Also, tomorrow, before I forget, is another mother who went missing, and it's possible it's at the hands of her husband. This one is in San Antonio. Suzanne Simpson. She's a mother of 4. This is eerily similar to the Suzanne Morphew story, which is interesting because they're both Suzannes, and both husbands have been considered potential suspects. We're going to get into that at a special time tomorrow, 12:30 p.m. So without further ado, I'm going to start with Stephen Webster here. I don't know if you followed the Sarah Boone case, Stephen Webster, but she's on her. I was up there covering it for 2 weeks, and she ended up with her ninth and final attorney, guy named James Owens. And the question now is Donna Adelson becoming Sarah Boone. She's now on attorneys 4 and 5. As we know, Dan Rashbaum, no more. Alex Morris, no more. Adam Komisar, no more. There was a mention of a guy named Tom Finley, I believe, who's also in Tallahassee, but they're gone. What do you make of this? We'll get into these two new attorneys. You're obviously in the heartbeat of all this in Tallahassee when you got the news that she hired these two attorneys who, again, I'll get more specific about. Your reaction?
Yeah, it's kind of strange. It's almost like attorneys gone wild or something with all of the turmoil down here. I did follow the Sarah Boone a little bit, especially at the end. I didn't realize that she had 9 attorneys overall. It's just really kind of remarkable. But we had a discussion earlier in one of your shows that I appeared on with Lewis, and I never was in favor of Dan Rashbaum trying to represent Donna after just having represented Charlie and having represented Donna before. I really did feel like that had all of the potential to create a conflict that couldn't be avoided and would cause the case to be either continued or even maybe bigger problems. I'm aware that Judge Everett entered an order last week, kind of sua sponte, directing the attorneys to conduct a thorough conflict check to ensure they don't have any conflict of interest that would prevent them from proceeding all the way through trial in this case and representing Donna. And that's a very unusual order. I have to believe that it's due to Jackie Fulford's prior representation, or I'm sorry, her having presided over the probate case. I'm assuming that's why Judge Everett entered that order, in order to try to make sure that she takes full responsibility for ensuring that that's not a conflict and can't create a conflict. But it's definitely strange.
Yeah, I think people are skeptical that it will move forward conflict free. Professor, sua sponte, for those of us who are not lawyers, what does that mean in English?
It means on his own motion without either the state or the defense lawyer requesting that he consider and make a decision on the issue. He did it on his own volition.
So people are asking, well, why are all these lawyers suddenly gone? All 3 attorneys so far have exited after Donna's son, Charlie, announced via his appellate attorney that he would not waive any conflicts of interest involving Dan Rashbaum's representation of him during his trial last year, and his mother. Of course, Charlie was convicted. I mean, Lewis, now that we've had time to digest this a little bit, how big of a mess is this, and can it be untangled, do you think?
So I'm an optimist by nature, so I believe it can be untangled. I think it's a gigantic mess. I think Webster and I, probably a week ago, had a very passionate debate about this at 7:00 in the morning. Your guests would have loved to be there, and I'm sure you wish it was recorded. It was a very passionate discussion that we had on this issue. And so in our views, and I have to say, right, to say it in front of the world that, Webster was right. We were on this show months ago, and Webster predicted that, this would be a major conflict in Rashbaum's representation of Donna Adelson. And my position was that I thought it was a conflict, but I did think there was a waivable conflict, and that with those waivers that he could continue to represent them both was my position, especially given that there would have been what we call a firewall, right, between Rashbaum and Alex Morris. And I thought that with that, firewall, that that would be sufficient to allow for the representation to continue. Obviously, I was wrong. In the law, lawyers make arguments and judges make decisions. And so Judge Everett's decision is super clear, extremely clear, that the conflict, Rashbaum had a conflict that was not waivable, and that he thought the conflict was so broad that it at that point had tainted Commissar, who was brand new to the case, right? Mm-hmm. So we look at the fact that he thought the conflict was so broad, Commissar was brought in to be the conflict cleaner, for lack of a better term. That's what he was. His sole job in this case was to be the cleaner. And he thought that the conflict was so messy that it had essentially tainted the cleaner. And so when we talk about answering your question, how much of a mess this is, unheard of, right? I have never seen or heard of anything like this. Every step that Rashbaum took, step one, bringing in Alex Morris, court says that's not enough. Step two, bringing in Commissar, court says that's not enough. Now we see the court, what Webster just mentioned, bringing in 2 lawyers who have not previously represented Charlie or any other co-defendant, and still the court on its own issues an order, like the professor just said. That's highly irregular, right? I can tell you, I have never seen, right, in practice of criminal law here in this circuit, I have never seen the court issue that kind of order asking lawyers to do a conflict check and be prepared to address conflicts at a case management. Mm-hmm. Case management is where you discuss scheduling, right? That's not where you discuss conflict. So this is highly irregular.
Yeah. So so Joe, what do you think? What's your best guess about how this all goes down? I mean, Joe, is the judge going to literally conduct an interview at this next case hearing, which is scheduled sometime in December?
Well, I do think that he is going to be, let us say, on the ball with this one. I think, once burned, he's planning to be very, very, very careful this time. And it's obvious from the fact that he made that motion. I don't know exactly what he's going to ask. It'll depend on, to some extent, on what the 2 attorneys say to him. But I do think that it's going to be more than a pro forma come in and tell me that you've checked and everything is copacetic. I think he wants to be sure that this time around there's not a problem. And I agree with both Lewis and Weber that it's just so extraordinary, and it's 2 separate runs of conflict problems, because one of them is Charlie's appeal, the other is Donna's trial. And then they're both running and providing what look like pretty serious issues that are going to have to be resolved.
Yeah. I guess Lewis is right. It's kind of unprecedented, at least in Tallahassee. Webster, to you from Jerry, how much can Rashbaum go and brief her new attorneys? And we'll tell you about these new attorneys again in a moment. How much can Rashbaum brief her new attorneys and bring them up to date, if at all?
He needs to stay away from this case entirely, 100%. Dan Rashbaum needs to not have any further involvement in any of these proceedings. He's operating under dual conflicts of interest. He has Charlie's conflict and he has Donna's conflict now. Having represented both of them, having been trusted with confidences from both of them. So he could maybe try to find a way, leave of court or new waivers from them that he could try to go in and facilitate in preparation of any defense, but it would be a horrible idea. Dan needs to just go away and stay away.
And I think that's probably, he's been awfully quiet. I haven't heard from him. And I assume that is what he's doing. Joe, and then I'm going to get back to Lewis in a minute, but I know you dug into some of the motions and some of the paperwork related to one of these new attorneys. What can you tell us about one of them being involved in Dan Markel's probate case? What does that mean? And is that a possible conflict here?
Well, yeah, it might be. That's Jackie Lee Fulford, who was on the bench for a while and was involuntarily retired for what the ethics committee said was a serious medical condition, whether physical or emotional, mental. I don't know whether the extent that will turn out to be a conflict. She handled the probate case for Dan Markel, and it doesn't appear on its face to cause any issues. But on the other hand, I do think that Judge Everett is going to be looking at this very, very, very closely. And I think if there's even a whiff of a problem that he sees, she's going to be off the case too. I mean, it's extraordinary, but I don't know how many lawyers practice in your area. But I mean,
not enough.
Like you're working through
Yeah. What about just hiring Webster and Baptiste at this point? What's the matter with that? With
I think they're probably tainted too. I mean, they've taken positions in opposition to her. So May not be tainted as far as an ethical issue, but they're probably not high on her list. They've talked too much.
Yeah. Well, listen, so Donna Sarah Boone Adelson is now, I think, on attorneys 4 and 5. This is one of them. And I apologize for cutting you off there. Josh Zellman, hired by Donna, Tallahassee attorney, criminal defense and DUI, a Miami native. He grew up right where I am right now, which is Miami Beach, and an FSU grad. Looks like a chummy fellow there. Louis Baptiste, I know it's a small community, so I don't want to throw you under the bus, but what do we know about this guy, Josh Zellman, if anything?
He's a smart lawyer. I mean, I'm in court with Josh all the time. I think I was in court with him last week on Wednesday or Thursday. I mean, he's a smart lawyer. I think that he's a I'll tell Webster, we were talking about, he's a tactician. I think that when it comes to breaking a case down and making legal arguments based on the case law to get charges dismissed, to get claims dismissed, to get evidence suppressed about law enforcement overreach, to get charges dismissed on stand your ground, like we see what you have on the screen now. That's how I would describe Josh Zellman, right? Obviously, he can handle himself in the courtroom. He's tried, murder cases. This won't be his first murder case. But I think that, his edge is the fact that he's such a tactician. I think that you need somebody like him on this case, because what's not being talked about is Rashbaum had 10 years of institutional knowledge. Georgia Kappelman has 10 years of institutional knowledge on this case. Sarah Dugan has 10 years of institutional knowledge on this case. Josh Zellman has 0, right? Jackie Fulford has 0, right? And so you need a lawyer who can literally shut down your practice. That's what you have to do, right? You have to take a deep dive into 10 years worth of data, of FBI reports, of police reports. I mean, it's no small thing, the task that he's undertaken. And you have to go compete against a Georgia who's lived these facts for 4 trials, right? And so I think that Josh Zellman is uniquely situated to handle that task, because he's the kind of guy that can get in the nuts and bolts pretty quickly. And that's what you need. And you need a lawyer, at least one on your team that can do that.
That's interesting. There's a question for you, Louis. So I'm going to toss it right back to you from Kathy. Mr. Baptiste, why did Rashbaum wait till the day of the first hearing, it was the day of jury selection, instead of doing his due diligence? What's your answer? I know you can't read his mind, but
I think that has to be like a setup. I'm not sure who did that, but Kathy, you must have had telekinesis back to the debate. Webster leaned. You saw he leaned into this, right? Because he knows. And so, look, I mean, I'm not going to get super into that debate, but I don't believe necessarily, like everyone else, that Rashbaum's conflict was so broad, right? I think that I think, I guess I'm trying to put this in a succinct way. Our debate was at least an hour and a half, 90 minutes. I mean, 90 minutes at 7 o'clock a.m. But
we should have streamed it. Next time, call me. I'll just start streaming it. But go ahead.
I think it's my position that the conflict applies as to his individual representation of a client. I do not believe that the conflict applies to the legal positions, right? So what does that mean in like plain English? I think that it's my perspective that Dan Rashbaum's conflict is the fact that there is a conflict in the fact that he took Donna Adelson off a witness list because he represented her if she could have been a good witness for Charlie. That's a clear conflict to me. The case law would support that position. I don't think it's a conflict if he stands up in Donna Adelson's trial and abandons the extortion defense. I think that since this is a new trial and they're not being tried as co-defendants, I think that he's free to stand up in this trial if he had tried it and take a firm position that fully abandons the extortion defense and even throws Charlie under the bus, right, is my position. I don't think a duty to a former client extends to the point where you can only talk good about that client, or you don't have to talk bad about that client, or you can't say that the position you took with that client before was a dumb position. I don't think the privilege is that broad. I'll stop talking now because I'm sure that my law partner disagrees, and he can opine on that.
Webster, feel free to rebut that statement in under 90 minutes. And then this question's for you too. If Dan could speak to you, and I know you knew Dan well, as did Lewis, how would he advise you to handle this mess that we're in?
Okay, you're going to hear me utter some words I don't know that I've ever uttered before. Lewis is wrong. He is just wrong on this. You know, as an attorney, we are the agent of our client as well, which is a whole nother problem here. So anything I present in a proceeding on behalf of a client is basically an adoption that is true and accurate. Look, it is just such a mess, and Rashbaum, he needed to get out, and he should have never been in representing Donna, and probably never should have represented Charlie either, as we're seeing now. But what would Dan tell me to do? You know, I think that Dan would he would just champion, you know, ethics and doing the right thing, fighting hard, but fighting clean, and working hard. You know, Dan was a very hard worker. In addition to having just the brilliance that God graced him with, he put in the work and was passionate about the law. And it was something that, you know, he studied, remained kind of active in at all times, and was always down to have a legal debate. And so I think, you know, that was the Dan Markel I knew, that, you know, he was a tactician as well, as Lewis referred to Josh. You know, he wasn't above setting a trap here and there for his opponent if he felt like it was going to serve the ultimate goal. But I do think Dan respected the law, and I think he respected the profession, and he would have never done anything to denigrate the profession. So,
yeah, I would agree with you from what I've heard about Dan on that. From Got Donuts in Toronto, who's a true character. Joel, is it time for the FBI to take over the Adelson clusters and arrest the other two? Joe Patuto kind of raises an interesting question. I've heard people say this needs to be handled by the feds. How does that work? How do you take a case from a circuit court and suddenly have a federal entity take over? There has been talk about this as well with Karen Reed out of Boston, because there's a lot of what appears to be corrupt law enforcement up there. So what about this? Is there some kind of nexus where the feds can take over?
Depends on what you mean by the feds. I mean, it is theoretically possible for the FBI to, well, certainly possible for the FBI to assist, but if you're talking about a federal prosecution here, there has to be a federal crime, and there isn't a general murder crime at the federal level. Those are state crimes. And I don't see that the U.S. attorney is going to have much interest in taking on this case. The case has already been fully, I mean, the FBI does investigations. The case has been fully investigated. There may be things at the edges that could still be investigated, but there's nothing left in terms, nothing significant in my eyes left in the investigation part. It's getting the trials through. And this thing is sitting in quite a bit of a mess right now. And listening to Lewis and Weber, I'm kind of in the middle on some of this. I mean, what's clear, I believe, is that Rashbaum in Charlie's trial could not have negotiated for Charlie a deal that would have affected Donna, and in Donna's trial couldn't negotiate a deal that would have put in jeopardy Charlie's case in case his appeal was reversed. There was no way they could do that. He could do that without it being an actual conflict with regard to each of them and both of them. I agree completely with Weber that Rashbaum should never have been in this case to begin with. I believe there should have been a much more thorough inquiry into the extent to which the conflict could arise. I mean, I said before, I think everybody thought that Charlie and Donna were kind of, together in all of this. They had consistent defenses. Neither was going to rat on the other, and they were going to succeed together or go down together. And nobody, I think, anticipated what happened, which is when Charlie rescinded the waiver, assuming that there was one in writing, but and decided that he now was in an antagonistic position to his mother. That wasn't anticipated, and maybe, except for Weber, it was unreasonable for anybody to go down that road far enough to see it possibly happening. But from here on out, now we're swimming, or the court is swimming, the prosecutor is swimming, Donna is swimming to try to work it out to go forward. And we have Charlie's case on the other side sitting there with him saying there should be a hearing at the trial level on the extent to which the conflict affected his representation and his fair trial. You would think this case would be over after 10 years, and instead it's erupting into, sort of a new run of issues, and who knows how long it's going to take now.
Yeah, and I've talked to Ruth Phil, not Shelley, but communicated kind of circuitously with her. But it's really sad because they are now questioning, are they going to live to see the end of this? Both in, I think, their early 80s. Both appear to be strong, spry human beings, so I would imagine so. But it's definitely not easy for either of them for this to be delayed anymore. Annalie Finch, happy birthday from all of us. Thank you for being here. Webster, to this question here from YFN, you're all Glanville. Why can Charlie be called to testify against Donna? Is there no law to protect you from having to testify against close relatives? I would imagine in a criminal case, call whoever you want to call. Is that right? By the way, Joe, I would never be so presumptuous to correct you on the law because you are a much smarter person than I, but it is Webster and not Weber.
Oh, sorry. I like Weber better. You want to change your name?
You can call him Weber. He doesn't. We're all going to call him Weber now. But Webster, what about this question?
There's a spousal privilege in Florida, so a spouse cannot be compelled to testify against another spouse, and the spouse has the right to assert the privilege against whom the testimony is being sought. But outside of that, there's no general privilege that prevents the state from calling a family member to testify against another family member.
There you go. Spousal privilege. Charlie can't marry Donna. Cannot happen. Julia Nielsen here. Lewis, if you had a guess, keep the questions coming. This is great. It's kind of a catch up on the Justice for Dan Markel story here. Obviously, the Adelson's a big part of that. But if you had a guess, Lewis, when would you say that this trial kicks off? I've heard January 2025.
Yeah, I don't think that soon.
I'm sorry. I meant a year from now, January 20. It's crazy how fast January 20. That's scary. But go ahead, Lewis.
Yeah, and I don't think that late. I don't think January 2026. If I had to guess, I'd probably say we're looking at a August 2025. October 2025 trial date. I think that Everett wants this case tried. Right. I think that this case needs to get tried. Everett wants it tried. Judge Everett is a docket mover. Right. And even amongst other judges, he's the kind of judge that every court date, he's telling you how many days old your case is. Right. And so he's active case management. So there's new lawyers. And so I can anticipate, because of the new lawyers, he's going to give them time to become acclimated and familiar with the facts. I do think that he's going to want this case tried in the summer, by the end of the summer of 2025. I will say that a big pause is going to be what the first DCA does, right? I think what the professor talked about earlier, which is we know Upperman has a pending motion at the first DCA to send jurisdiction back for the first DCA to relinquish jurisdiction because courts are not going to exercise concurrent jurisdiction. And so for the trial court to take the case back, the DCA has to relinquish its jurisdiction. And that's what Upperman is asking the first DCA to do. We know the Attorney General's office is asking the first DCA to not relinquish jurisdiction and allow Charlie Adelson to file a 3850, which is, ineffective assistance of counsel claim. And so I think that that's really what Everett has to be waiting for, right? If you're Judge Everett, you can't possibly even be thinking about setting this case for trial before the first DCA rules on that issue. Because if the first DCA does relinquish jurisdiction, then the meat and the potatoes for Judge Everett is going to be deciding deciding and setting a hearing, an evidentiary hearing on Charlie's motion. If the first DCA says, no, we're going to keep it, then Judge Everett knows that he has to focus on getting Donald Adelson's trials done. So I think that decision by the first DCA, the District Court of Appeals handles all appeals for these several circuits. So Florida's broken down into 6 circuits. It was forever 5. In the past year, we added a 6th circuit. And so any case that's appealed from Tallahassee in particular has to go to the first DCA, which is located here in Tallahassee. After that, it's the Florida Supreme Court. So I think that's going to be the key decider, is what do they do on Charlie Adelson's case? And I don't think Judge Everett's going to be able to do anything before that decision, in my opinion.
From Mark in the chat, there's a question: will there be legal consequences for Rashbaum? I don't know, but I do know that the bar is taking a good look at him. There's an inquiry into what happened. I don't know how long those take, or if maybe Webster or Lewis knows something else. But back to the professor from Annie K, always with the smart questions. Do Rashbaum's actions potentially affect Charlie Adelson's appeal grounds? Now we're getting into law school questions. Joe, if so, this seems like a very complicated answer, I guess.
In a way it is. It depends on what appeal means. Generally speaking, and in Florida, you cannot raise a claim of ineffective counsel on direct appeal, and that's where Charlie is right now. But that claim is available on post-conviction relief, so that if he ran his appeals on whether there were errors at trial, whether something in the direct case warranted reversal, and he lost, and now he's sitting, no more appeals to run, he can then start again at the trial level and raise the ineffective assistance of counsel claim, and that relates to the conflict. What that motion to relinquish jurisdiction is about is his lawyer saying, rather than wait to the post-conviction stage, go through the appeal time and then come in again, we want it sent back down and have that resolved now. And whether it's on appeal or on post-conviction, the issue that's sitting in all here because of Rashbaum, the one that the appellate lawyers are raising, is the issue that was alluded to before, that at Charlie's trial, the state listed Donna and Harvey as witnesses for the state. When that happened, Rashbaum listed them as witnesses for the defense. They ended up both agreeing that neither side would call them, and that's the way the trial proceeded. What's being argued is that Rashbaum did not call Donna at Charlie's trial because of his conflict in the prior representation, and I think the argument is the potential of the later representation of Donna, and that had not been there, he would have called her. What Rashbaum has said, and that part of it is described in the state's response to the defense motion, is that he never intended to call her, and that the only reason she ever got listed on his list was because the state was trying to do an end run and get information about what his, that was going to be the secret defense at Charlie's trial, get some view of what that defense was going to be, and that's the only reason why he listed her. That question as to whether, one, it's true that that's the only reason she got on that list, or whether Charlie's lawyers are going to be able to make some sort of showing that there were other reasons for calling her. For example, her testimony would have supported his story, and that might have helped him in his case. Is this question that's looming out there as to whether his trial was affected by the dual representation?
Man, you could teach a law course. What about this, Joe Patuto? Is this true that Joe was the second female law professor in the country? Is this true?
I'm not that old. No, there were many. In fact, I had two or three women law professors when I was in law school.
I was going to say, because I think you started back in the 70s, and there had to have been law professors.
Well, Ruth Ginsburg was a law professor, among others. There were plenty. Even there are many, many, many more now, but there certainly were many. There have been many through the years.
Wow. Well, we'll say you're the second best ever after RBG. How about that?
Well, I guess I'll accept that.
Okay, there you go. Webster Lewis mentioned 10 years of discovery and a trial, possibly a year from now or sooner. Just paint a picture of how one can wrap their head around 10 years of discovery and be prepared for a trial in less than, basically in less than a year or a year. It seems like a really, really big task at hand.
It is. It's a lot of work. I agree with Lewis, though. I expect this case to go to trial in August, September, October of 25. I think if for some reason Josh or Miss Fulford decided that they needed more time, that I think Everett would be, beneficent in that regard, or benevolent. But I do think that that's probably what the court is looking at. Here's the deal. I mean, the good news is you have trial transcripts, you have multiple depositions. Most of the witnesses have been deposed, many of them multiple times. They've testified at numerous trials and proceedings. So you have an opportunity to really kind of get in there and see in live time what to expect and get a feel for it. I think that the difficulty might become in trying to keep a fresh outlook on things, and look at motions that were filed and maybe that shouldn't have been filed, or different motions. And I think that would be the danger here. The professor talked about Charlie's secret defense. Frankly, he should have kept it a secret. He should have that should have remained forever a secret that never got out in the light of day. And so, the attorneys really do have to try to figure out what is the best approach to presenting the evidence and attacking the evidence without kind of getting tunnel vision with what's already been done and gone before. But they certainly have a lot of opportunity to come up to speed.
Yeah,
and Josh is a hard worker. Like, Lewis talked about, he's a tactician. He's a hard worker. I've had the opportunity to work around Josh and work on cases with him and see him in action. And he will put his nose to the grindstone. And so will Jackie.
Yeah. And someone asked, where do you start? Where would you start with this discovery?
I would probably start, with the trial transcripts. I would go right there, see how did they testify at the trial? How did the state present what was the order of proof for the state? And then I would go back and cross-reference all of the discovery and probably start looking at any exhibits that the state didn't use, any witnesses they didn't call, try to figure out why didn't they use certain exhibits, maybe why didn't they call certain witnesses, and, really kind of hone in there. Obviously, you got to speak to your client and understand what her account of the version of the story is. And, if I'm Josh or Jackie, I'm just praying to God that she's not going with the double extortion theory.
Let's hope so. Lewis, back to, and you can feel free to answer this one. They want to know how you two, Webster and Baptiste, met. But before you answer that, a couple things that were mentioned, and you mentioned one of them, the 3850, which is ineffective assistance of counsel. Is there, I don't know, a world where either Donna and or Charlie now claim that they were given or had ineffective assistance of counsel because he allowed this conflict to happen? Let's start there, I guess.
So I don't think Donna can claim it, right? Because Donna has had the ability to get new counsel and effective counsel. And so even if Rashbaum had gave horrible advice a year ago, since Donna's case hasn't been to trial, under my understanding of the standard, she wouldn't have a claim, right? She can't say, well, he gave me bad advice that set me up to be in this position. But it's not how the courts look at it, right? The courts are looking at it from a trial perspective. Did they fail to call a witness? Did they fail to chase down a lead? So now she has new lawyers who presumably have the ability to call any witness, chase down any lead, discover any information. So I don't think she'll have one as it relates to Rashbaum at all.
Mm. How about this? How did you guys meet here? This is, and then we'll get back to Charlie.
Yeah. So, this story is born out of a debt to Dan Markel. Dan Markel was my law professor. He taught me criminal law my 1L year. And Dan Markel and I didn't agree often. And honestly, we disagreed more than we agreed. He was a big scholar in retributivism, the theory that if you do a crime, you should be punished, right? That crime and punishment flow hand in hand. I'm big on utilitarianism, the idea that we should only punish to the extent it's going to help rehabilitate somebody. And so as a 1L, we often disagreed. And then the professor knows that, he's a Harvard, Oxford guy. Here I am telling him, you're wrong. I disagree. And so I didn't think he liked me much, honestly. I didn't. And I would raise my hand and he would just not call on me. And I would keep it up. Like, it's not going down. You're going to get this hand. Because, criminal law is such a passionate subject especially for 1Ls. And so a month into the summer, I wasn't working. I didn't have an amazing clerkship. I was at my house changing oil on an old 2002 Ford Explorer. Webster remembers that car. The windows didn't go down. And so I was changing the oil and my phone rings. And I should have picked it up because my hands are oily. I'm literally trying to put the bolt back on the oil pan under the car. And I pick up the phone and it's like, this is Attorney Webster. And I'm like, Attorney Webster? Do I owe somebody money? Like, what is this? He's like, I'm calling to offer you a job. Offer me a job? I didn't apply for a job. Like, I've heard good things about you. Are you interested in the clerkship? I'm changing oil on an 02 Ford Explorer. The windows don't go down. All I have in my pockets is lint. And so I said, of course I'm interested in the job, please. And that was in 2014, 2 months before Professor Markel was murdered. And I learned later that Professor Markel, Webster was obviously representing Professor Markel. And Webster went to Professor Markel and said, look, I have business. I can use a law clerk. And Professor Markel thought enough of me to recommend me for that position, even though all we did was disagree 10 years ago to this day. And out of that recommendation, a partnership, a brotherhood, family has grown from that recommendation Professor Markel made 10 years ago. That recommendation changed my life and my ability to provide for my family and my extended family and my ability to represent people and help them. That one recommendation. And so I owe Professor Markel a debt that I can't repay. If he was here, I would, buy him 100 ribeyes. I would do something to repay the debt. But all I can do to repay the debt now is tell people how awesome of a guy he was, how when my grades didn't justify it, he placed a bet on me, and hope that I am living and practicing in a way that he would respect, because he was such a great lawyer, and even a better father.
Yeah. I guess he appreciated the fact that you wouldn't put that hand down. From AA here to Webster, hasn't Donna, and this has come up a few times in the chat, hasn't Donna given up her rights to a speedy trial given what Dan caused? That's an interesting dilemma. I mean, we all know that she wants out of jail. She's stuck in there now. What about that constitutional right to a speedy trial? It's kind of been derailed because of Dan, right?
Well, the initial request for continuances that were made by Dan and Alex would have eliminated her initial right to a demand of speedy trial, but she could revive it once the time, 175 days, has expired, she could demand a speedy trial, and then it would initiate an investigation by the court, and the court would have to bring it to trial. I can't remember what it is, Lou, 60 days or something like that, I think.
60 days. Yeah.
And
Capture period.
but here's the problem with that. When a lawyer announces when they demand a speedy trial, they're announcing to the court that they are ready to try the case. So, that's the problem. There's no way that Mr. Zellman or, Ms. Fulford at this point, either one of them could stand up in the near future and tell Judge Everett, we are ready for trial. I mean, it's hard, and Jackie's a hard worker too. I worked with her at the state attorney's office. I've known her for a lot of years. Even as diligent as they are, there is a lot of information here to consume. So, it's something that they could do at some point and say, look, we're ready, we want to go. But I wouldn't look towards that happening. I think that, like Lewis said, I think, Judge Everett's going to push this docket. They're all going to at this point be understanding that time is going to be required to get up to speed. And, you can look for this trial. Like Lewis said, I really think his prediction's spot on: August, September, October of 25.
So I just want to get through because we got another attorney, but it is interesting. He was Josh Zellman, the first attorney in North Florida to win the dismissal of criminal charges on a stand your ground law. He also won a temporary insanity and attempted first degree murder charge. So you heard them say that case was State of Florida versus Jeffrey Brown. It involved a gang shootout that left a 15-year-old dead back in 2008. I think that was the stand your ground one. And then he was successfully used an insanity defense. He also later, and I found this in my research, litigated the right of a court-appointed litigated the right of court-appointed attorneys to fair compensation in non-capital cases and clarified the analysis courts are required to conduct to establish fees in such cases. That does seem very kind of tedious, but you heard Lewis say he's a tactician, so sounds like he does get into the weeds a bit. This question has been sort of lingering too. I'm going to toss this one to the professor here. Dan's conflict, does it open a door to investigate his involvement in Donna's attempt to flee or other possible cover-up? Of course, we heard it on I believe it was the jailhouse calls in the week after Charlie's conviction, Joe, that she was being guided by Dan, presumed to be Dan Rashbaum, about basically getting out of Dodge. We know the rest of that story, that she tried to flee to Vietnam. I guess what kind of trouble could Dan Rashbaum be in potentially for advising a client if he did to do that?
Well, as I understand it, at the time, she was not charged with anything and was free to leave. It might not have been the best thing for him to do, but it doesn't appear to be something that would lead directly to ethics charges. Now, that being said, there's an ethics complaint that's been filed, and they are going to be investigating whatever the claim was that brought it to their attention to begin with. I have no doubt that this involvement and his involvement now in potentially 2 trials that may go awry, will be something they're going to look at. The advice to Donna colors an evaluation of his professionalism. It may not be directly related to anything, but it provides a picture of the lawyer that is not helpful when a fact finder, and in this case the ethics committee, is evaluating the extent to which there may have been ethical violations. But I don't think it's directly one that would lead to an ethical either a charge or a finding in itself.
From Goose here, why are we so mad? It's an interesting point. Webster, you want to field this one? Why are we so mad at Charlie? Can we blame him for doing what he has to do? Imagine facing life without parole. What would you do? I'll take it a step further. I think that he could very well throw at some point his mom and or Wendy kind of, flip on them. But do we need to respect the appellate process and the judicial process here, Webster?
Yeah, I mean, I'm not mad at Charlie. I'm disgusted by Charlie because he murdered Dan Markel, the father of 2 boys, and my client, and Ruth and Phil's, amazing son, and Shelley's amazing brother. So I'm disgusted by him, but I'm not mad at him for this. I mean, I blame Dan Rashbaum for this. Dan was the one responsible for this. Charlie had every right to withdraw his waiver to the extent that he ever did provide a waiver, because it wasn't even in writing. But once again, as Lewis indicated, we had a spirited debate about it. I just don't, I never felt like this was a conflict that could be waived. It's just grotesque in my mind, the idea that a lawyer is going to stand up in a courtroom and potentially make arguments that are diametrically opposed to arguments he made on behalf of another client and related to the same exact proceeding within a year's time of having stood up in court and advocated for Charlie. If he never planned or even gave thought to the possibility of doing that, then all of that would do is highlight the conflict of interest more, because Charlie's trial went miserably for Charlie. I mean, that jury, they barely even ordered lunch, and and came back with their guilty verdict. So it definitely deserved a full evaluation as to what was the best approach to take with Donna. Charlie, at that point, I think there's no way ethically he could stand up and say anything other than, advancing the same double extortion theory. And that's if Charlie agreed and allowed to have it continue and happen. So I'm not mad at Charlie about that. I mean, he had every right to do it. And frankly, he should do it. Upperman and has given him sage advice in that regard. I mean, the conflict is troublesome, and it's going to be an issue somewhere along the line. I don't believe, after reading the state's response, that there's enough to relinquish jurisdiction back to the trial court. I'm taking the state's, evidence or case law at face value that they presented in their response. But according to the state's response, there has to be an actual conflict. And it's even questionable whether or not this idea of relinquishing jurisdiction is a real thing. There was the case that originally kind of set this up has been somewhat kind of called into question by a later ruling. But at a minimum, it seems like the state's position, according to the law right now, is that the only way they could relinquish jurisdiction, as opposed to doing what the law professor said, which is do your direct appeal and then raise the ineffective assistance claim in a post-conviction proceeding after your direct appeal has been disposed of, would be that if there was an actual conflict of interest that was ongoing at the trial and it had to create a fundamental problem with the trial, a fundamental, basically violation of his right to counsel. And as the state noted in their response, Charlie's lawyer in the trial court told Judge Everett, it's a potential conflict. It's not a conflict right now, Your Honor, but it will become a conflict if Charlie takes a stand and is subject to cross-examination. So according to that kind of statement in court, the state latched onto that and said, the defendant acknowledged that there wasn't an actual conflict in existence at the trial, and it only was a potential conflict that could only arise in Donna's subsequent trial. So therefore, you can't relinquish it. The law doesn't allow that. They have to go through the normal process of disposing of their direct appeal, then raising it in post-conviction as a 3850, as Lewis said. So, but Charlie, Michael Ufferman's a very smart attorney, and he's appellate work is all he does. And so, he wisely is not going to miss the opportunity. But I do think it changes the analysis. If this is ultimately resolved on as a post-conviction appeal, if you will, and the Strickland factors would come into play as regarding an analysis of ineffective assistance of counsel. It's not an easy burden to meet. It's not, you have to show, but for the ineffective assistance of counsel, the conviction would not have been returned. And I don't even, at first I was a little bit seasick and queasy about this, but the more I've read it and looked into it, I don't know that I really like Charlie's chances there. If he doesn't prevail here with this kind of Hail Mary, then I think he's still going to be sledding uphill.
That was a really interesting breakdown of a very complicated situation from Michelle Crawford to Lewis here. has Josh Zellman, this new attorney, has he ever, gone against the formidable team of Georgia Kappelman or Sarah Dugan? You said he was in court with you. Has he been in court with them?
Yes, absolutely. I don't know that he's gone against them together. A lawyer like Georgia and Sarah don't try many cases together, right? They're both division chiefs. So they both try very serious cases, murder, rape, sexual battery. They try those kind of cases, but they try them individually. Dugan has her division and Georgia has her division. And so it's rare that you get that kind of powerhouse team on one case. I mean, it's extremely rare. And so he probably hasn't tried a case against both of them, but he absolutely has. I know for sure he tried a case against Georgia. We were talking about it, a couple of weeks ago, and I think in that case he was talking about, that was a case where he was talking about novel legal issues that were presented in that case. And so I have no doubt that he's tried a case against both of them. But if I will pick up, I think again, I'm not going to go to a 90-minute debate, but I think something Webster said is extremely interesting, right? The appellate court, and I call it the AGs, right? Because the attorney general handles appeals for the state. And so the attorney general is arguing that Rashbaum himself said that it was a potential conflict, not an actual conflict, unless Charlie Adelson takes the stand. But if you're Judge Everett, you have what you have now labeled the conflict-ridden lawyer describing what could or couldn't be a conflict. And so if you truly believe that Rashbaum had a conflict the entire time, that he never had the ability to represent Donna Adelson or Charlie Adelson in Charlie's trial, or Donna in her new trial, then how do you take any of his statements regarding any of the legal positions at face value, right?
It wasn't him, Lewis. It was the attorney that works with Upperman. He said it on the morning of the conflict. So it's his appellate counsel that made that statement that it was a potential conflict.
Niles.
I don't want a 90-minute debate.
Too. Okay. I know Niles said it. I thought he said it too.
From Nicole Luongo here to Joe. Interestingly, of course, coming off of Sarah Boone, who was on her ninth attorney. Is there a limit? By the way, Sarah Boone's verdict came back in a half a Charlie Adelson verdict. I couldn't even get downstairs in the elevator before I had to go back up for that verdict. I think it was an hour and 21 minutes with dinner before they found her guilty. But is there a limit, Professor, on the number of times the defendant changes attorneys for the same trial? And while you're at it, Strickland factors, no idea what that means. So if you can explain that, because that's something that Webster just mentioned.
Yeah. Theoretically, there's no limit because actually the issue doesn't come up very often. You hire a lawyer, the lawyer takes you through the trial and you're done. So this idea that you actually have to figure out when enough is enough is not something that judges encounter very often. And what happened is, in the Sarah Boone case was the judge finally said, you've had enough tries at this. I'm going to treat it as though it's your request to go pro se. So go ahead and do it. And then, of course, she sent that ad out and got, 3 lawyers to come in, we think pro bono, to take on that case. So there's no limit, but the issue doesn't usually arise. And in Donna's case, it's really not attributable to her. I mean, it is in the sense that she hired Dan Rashbaum to begin with, and that's what started this ball rolling. But it isn't as though she's been obstreperous or a difficult client to work with, or she's pushed lawyers out because they won't do what she wants. As to Strickland is a U.S. Supreme Court case that deals with what it takes to show that a lawyer was ineffective at trial, so much so that the client was not given a fair trial under the Sixth Amendment. And the Strickland test has 2 parts to it. One is the assessment of whether the lawyer's representation was sufficiently deficient. And with that part of the test, the court has said you defer to the lawyer because lawyers make tactical decisions, and it's very difficult on a cold record to decide why a lawyer did something or didn't do something. So in deciding whether that lawyer's representation was deficient, you're going to give every doubt goes to the lawyer, and a conclusion the lawyer operated correctly. If the conclusion is that the lawyer did not meet even a minimal standard of representation, the other question is whether that level of ineffective representation in terms of what the lawyer did affected the trial so much that had the lawyer done the job adequately, the result at trial would have been different. So in Charlie's case, the question would be, if you decide the representation was so deficient, would you also say that because of that, the jury might have, there's a reasonable chance that the jury would have acquitted rather than convicted. So it's a very, very, very tough standard. There's more leeway with conflict of interest because you can't tell on a conflict. It's much harder to tell whether it would have affected the jury result than, other things that can happen in trial. But that's effectively the Strickland test.
Mm-hmm. Just thinking this whole time, if I was in law school, I'd have to reread every line of every book 1,000 times before I actually got it. And it would probably take me forever to get through law school. This is the other attorney, Jackie Fulford. She's a little more controversial of the two. Not sure why she has a little Band-Aid going on the right side of her face there. Former circuit judge, former chief assistant state attorney in the Second Judicial Circuit. She was appointed by Governor Charlie Crist as chief assistant state attorney. She held that role from 1998 till 2009. Charlie Crist says back then she possesses the integrity, dedication, and knowledge to being an impartial and successful circuit judge. 2010, she's re-elected. And then 2015, everything kind of changes around. She's forced to retire due to a disability, investigated for alleged misconduct during her time on the bench in Wakulla. That, incidentally, is where the correction center is that Charlie was sent to. She also happens to own a funeral home with this gentleman since 2019. It's an interesting combination of careers, criminal defense and funeral home owner. You can... they're convicted. You can just send them to the funeral home afterwards, I suppose. But Webster, to you, and I don't want to put you in a weird spot because I know you work and live in Tallahassee like Lewis, but she's a bit controversial. I mean, she's had kind of a checkered past. What do we know about her?
Well, I know her very well. She actually officiated my wedding.
That's good.
And she was present when my youngest child was born. So I know her son, so I don't want to disparage Jackie. I can tell you our lives have kind of diverged over the years. Life does that. When I worked with her at the state attorney's office, which is really where my friendship with her was born, she was, I considered her to be very ethical when I was there. I remember I went to her with a case. I was concerned I was going to have a judge grant judgment of acquittal against me. I was concerned I didn't have enough evidence to even get it to a jury. And it was something I never wanted to do, is to take a case that I couldn't get to a jury. So, because I felt like that would be a question of my ethics. So I went to her, and most supervisors at the state attorney's office, at least, they tell you march. If you go in there and say, I'm really thinking I may have to just drop this charge, their kind of go-to response is get in there and try. Go fight. And she didn't. She looked at it and she told me that she said, you need to drop this one. I don't think you've got enough. I didn't listen to her. I decided I met with, I had one witness that I had to rely on to get past JOA, and he didn't deliver. He came in and equivocated. And I barely got past judgment of acquittal. And he was acquitted. And so the jury actually asked Judge Thurstrom if they could come back into the courtroom. They wanted to address him. And they came in and said, look, we acquitted you, but in no way should you take this as a belief that we think you're innocent. On the contrary, we absolutely think you did this, but we took an oath to follow the law, and we didn't feel like under the law we could say that the state proved the case beyond reasonable doubt. And that's the only reason why we didn't convict you. And that said a lot to me that Jackie told me that, because like I said, the go-to with supervisors up there is don't drop anything. You go forward, and if you just take your lumps. That's how it works in the state system. The feds are much more selective in what they prosecute. And so, it was kind of an important moment for me. And frankly, I wasn't involved with all of the stuff that went on once she was on the bench. Unfortunately, it's been said many times, a judge's life is a lonely life. Once, especially in a small legal community like this, once you become a judge, it's hard to kind of associate with your old lawyer friends because they may have cases that come before you, and it just kind of makes everything awkward. And so we just kind of drifted, distance. Our lives went in distant directions at that point. And so that's kind of where I'm at on that.
1776 daughter. Hey, STS, what trial will we be following next? I absolutely love being back in the mix, covering Sarah Boone. I don't know how much my kids liked it or the COE, but send suggestions. Surviving the Survivor at gmail.com. Definitely going to be covering more trials as we move forward. So again, surviving the Survivor at gmail.com. Lewis, I don't want to harp on this, but I think it's important here. The 5-page notice back then of formal charges related to Judge Fulford that was filed with the Florida Supreme Court cited several instances of alleged inappropriate conduct back in 2012 and 2013, including publicly opposing a candidate for elected office, using her position to influence attorneys, and helping the son of her significant other in a domestic battery case, which it seems pretty serious. Again, this is a long time ago, over 10 years ago, but this is a woman who basically had her judgeship stripped from her and is now being hired by Donna. I guess my question is, why is Donna even going near someone who's another potential conflict? Because I'm hearing the state could have some opposition to her representing Donna. What's your take on all this?
And so I never had the ability to practice in front of or practice with Attorney Fulford. When she was leaving, I was coming. But so I don't know anything about those allegations. In 2015, I was trying to pass a class like the professors and hoping to get a good grade in constitutional law. And so I wouldn't have been around for any of that. But I can tell you, I think I saw Attorney Fulford in court 6 months ago, give or take. And I think that her reputation is that she's a trial lawyer. And so, there was a question I saw in the panel. Somebody asked, when's the last time she tried a case? It probably, wasn't last week or last month, but it's like riding a bike. And if you were to count the amount of trials that she has had, right, you're talking about a large number. You're not talking about a lawyer who has 10, 15, 20, 25, 30 trials, right? Her jury trials far exceed that number. And so I think that if she does stay on this case, I can tell you, I think that I'm like Webster in that the fact that she was a probate lawyer, makes me, raise my eyebrows. But again, I'm not the bar. I'm not the JQC. I don't want to be the bar, and I don't want to be the JQC. But I think that if she does stay on the case, she's a lawyer that can call on decades of experience, right? You don't become the chief assistant by not trying cases. And so I think that she's not someone you can just ignore, right? She's not somebody where you can just look at the allegations from 2015 and think that, okay, or think about the disability that was noted and think that that's easy lunch, or, that's an easy taking. I think that would be a big mistake, and one that Dugan and Georgia are not going to make. Fulford knows how to try a case, and they know she knows how to try a case. And so because they know that, if she stays on the case, she's a lawyer you're going to take serious, right? I'd imagine she's tried as much murder cases as any one of them. And so, that's who they're competing against.
By the way, the JQC is a 15-member independent agency that actually investigates alleged misconduct by judges, state judges. So they're kind of a watchdog. So that is what the JQC reference is. Joe Patuto, and just a couple more minutes, and then we're going to wrap things up here. It is the World Series Game 3 in the Bronx, Space Coast. That's why I'm wearing my Yankees hat. How about the significance, assuming that, she stays on the team, of now having a female attorney? Is there anything to that, or is that much ado about nothing, Joe Patuto?
I don't know. I know a lot of people, and a lot of very good lawyers pay attention to the gender of the lawyers representing, particularly when it's a female client, a female defendant. I have never felt as strongly about that. I think a good lawyer is a good lawyer, whether male or female, and that if I were a defendant in a case, I'd want the best lawyers I could find, and gender would be probably not a consideration for me. And in this case, I'm not so sure. And I think maybe Webster and and Lewis may be better positioned to talk about this. I'm not sure there's anything about this case where having a female lawyer representing Donna will make a significant difference. So I don't know. I think if she got the lawyers she thinks are the best lawyers to represent her, then great. And I guess I would say one thing about Jackie Lee Fulford. That ethics claim that went before the Judicial Qualifications Committee, because she was removed from the bench. They said involuntarily, but she signed off on it for medical reasons. The allegations were never proved. They were made, but there was never a finding about any of them, and we have no idea whether if that had gone on to an actual full investigation and hearing, whether there would have been a finding. She certainly had a response to the claims that were made.
That's an interesting distinction right there. So the accusations never actually, came to fruition. There's a question here, Lewis. How many lawyers could win a not guilty for Donna? What's your answer to that? There's got to be someone.
I don't know any. I think that's easy. I don't know any. When you think about the bump, you think about the mountain of evidence, you think about the dress the kids up in the uniforms, for a term I don't use. You think about the fact that she was the bookkeeper for the business and the payments to Magwana. I think there's just so much bad evidence here, right? I think that I will pick up on where the professor left off. Webster and I actually talked about this. I do think her having a lawyer, and I don't subscribe a lot to gender, but I do think her having a lawyer that can bring out empathy, right? Donna comes off as cold. She doesn't come in calculated, egotistical, selfish. That's how she comes off, right? Even when she's sitting there quiet, like if you watch her in hearings, right? It's just how she comes off without even talking. And so I think when you have a client like that, you have to get a lawyer that has the ability to bring out more empathy, and a lawyer that has the ability to make the jury like that person. And so in Donna's defense is going to be just as much as it's about what the lawyers are saying. To me, it's going to be about whether or not that lawyer has the ability to make the jurors like them enough to look past their dislike for Donna, right? And so she needs a lawyer that can do that can make the jury like them, so they like Donna just a little bit because of how much they like the lawyer.
Webster, I was going to ask this question in a different way. The final question, and then we'll wrap it up. From MJ, state's response to Charlie's motion. You discussed it briefly, but basically, they think there's not enough there, from what I understand, even to have this hearing, if I understand it correctly. But where are we at, and where does this end up, you think, with Charlie, Webster?
Well, I would like just to say that, I find it incredibly distasteful that Jackie presided over the probate case for Dan, and now chose to represent the accused murderer. I just think that is so unfair to the Markels, they must really feel betrayed by the system at this point. Seeing,
Why isn't that a conflict? I don't get it.
I mean, here's what I'll say to that. There's not a case in history, I guarantee you, and as a lawyer, I guarantee nothing, but I guarantee you could scour every legal textbook from here to kingdom come, and you won't find a case where a judge who presided over the probate proceedings of a murder victim went on to represent the defendants accused of murdering that victim. So there's no precedent for this. I'm confident of it, having not made any attempt to look. But I don't know if it creates an actual conflict of interest or not, but it's gross. And it just really is gross. And like I said, I feel for the Markels, because they must feel like the system has no integrity and has betrayed them once again. So, but as far as where I see Charlie going, after I read the state's response, and I thought it was well put together. I thought the case law that they cited, I felt like they did a great job of assimilating and boiling down the case law. The arguments were very kind of cogent, and I was able to follow it. I felt like pretty easily, thanks to the great job that it's actually Mr. Meg's daughter did writing it. But in essence, there was a case early years ago where there was an alleged conflict of interest, and there was a motion to relinquish jurisdiction back down to the trial court because none of that was built into the record for the appellate court to review. And the appellate court did that. But since that case was, the holding in that case came down, there was another case where it seems like the appellate courts kind of pulled the reins back on this a little bit and said, wait a minute, we have a proceeding built into place where you can challenge ineffective assistance of counsel. And it's not by relinquishing the case back down to the trial court. It's by finishing your direct appeal and then coming back with your post-conviction relief motion, claiming ineffective assistance of counsel. And I felt like the state did a great job of outlining why that should be the case here, and in going all the way to the extent of pointing to the actual words that were presented to the court by Charlie Adelson's appellate attorney at the hearing, where she said, there's not an actual conflict, Your Honor. There's a potential of a conflict of interest. And the state wisely pointed out that basically should disqualify them from the relief they're seeking. That in order to get this relinquished back to the trial court, they have to prove there was not only an actual conflict, but they have to prove that it caused a fundamental flaw in the trial proceeding underneath. And so they said they can't even meet the first prong because they've admitted on the record that it was not an actual conflict, was only potential. Therefore, it shouldn't be relinquished and it should just proceed as normal. So I believe now, after having read those, the motion and the response, that's where we're going to go. I think it's going to be denied, and then the direct appeal is going to be disposed of, and then he's going to file the post-conviction, and it's going to be an interesting fight. I mean, it's problematic. Unfortunately, what Mr. Rashbaum chose to do here has created a problem. And I don't know, ultimately, like the law professor said, it's a high burden to meet that standard on post-conviction relief. There can't be some strategic or tactical reason for it. As she also said, given that he's a conflicted lawyer, what sort of strategy does he have and who is he strategizing for? I mean, these are all problems and questions, but at the end of the day, they have to be able to show that but for his conflict, the jury would not have convicted him. That, in essence, that's the ultimate standard. And that's the burden on the defendant, that but for Dan's conflict, this jury wouldn't have convicted him. And I think there's probably 1,000 reasons in the record why an appellate court could determine that it wasn't Dan's conflict of interest that caused the conviction, and but for his conflict, he would have been convicted anyway. And I hope
that's a very clear, concise way of putting it. Webster, you're right back up. We got something to tee up here that only Webster can, and only on STS. Webster, you tee it up and I'll roll it.
So as Lewis spoke earlier, and some of your guests may have seen from past episodes, I thankfully, thank God for Dan Markel and my brief friendship with him. Because of my brief friendship with Dan, I met a friend that'll be my friend in the rest of this life and beyond, and a brother. And not only that, but he is literally like a father, second father to my children, an uncle to my children, like a brother to my wife and all of my family. And that's Louis Jean Baptiste. It's been one of the greatest blessings of my life getting to know Lewis. And thank you, Dan, for doing that and delivering him into my life. And in that regard, Lewis, in short order, is going to be a father. And it's no man will ever be a better father than Lewis. And no offense, Dan, but Lewis, he is a father to nieces, nephews, to cousins. He is literally just one of the most giving, beautiful human beings you'll ever know. And his daughter, soon to be daughter, is going to just know love like she's never known. And in that regard, I reached out to Bruce Buffer, who is the ring announcer for the Ultimate Fighting Championship, UFC. He's the king of the octagon. And I asked if he would mind just maybe sending a little message to Lewis, giving him a little bit of advice moving forward in this next chapter of his life.
Who better to do this than an announcer, a professional announcer, Bruce Buffer, the UFC world famous.
Get ready to have no slumber. Louis and Christina, congratulations on bringing in the next world champion. In this corner is what you thought you knew about love. And in this corner is what your beautiful daughter will teach you about love. May God continue to bless you as you are both undefeated as the pound for pound most incredible people in the world. The Websters love you more than you could know, and they can't wait to meet that beautiful baby. May God always bless your beautiful family.
Wow.
COE, I am jealous right there. That
Get
is, you
ready
know that. Oh, wait, we can't listen to that twice.
Wow.
But Lewis, I'm a huge UFC fan. I've met Bruce Buffer many times. He's actually a nice guy. A little cheesy at times, but nice. What do you think of that?
Wow. I can't follow that up. And that's wow. Like that's insane. But wow.
When's the baby due?
It's November 18th. So we're like my wife's 7 weeks
yeah.
today. So we're like in the any day now. And she's healthy, and God is amazing, and He's been amazing to us, and we're just grateful. Wow, thank you, Webster. I mean, that's who Webster is, right? Like that's just, I'm really speechless, but that's who Webster is, and obviously that's why I love him.
I can't render him speechless with debate, so I got to find some way to do it.
Well, that's a big mazel tov to you,
Love you, man.
and we're excited to celebrate the occasion. And I'm sure STS will send the baby some swag. Of course, we'll be all over that. Just a quick reminder here, by the way, just another amazing panel, which we are used to. Ruth Markel is going to be in South Florida at a place called JAFCO, JAFCO, on December 22nd, talking about quote unquote meaningful conversations. It's going to be a really amazing night. Please, here it is. This is the flyer. There's a link in the chat. We'll put a link into the shows. And then tomorrow night, if you guys are interested, this is a purely virtual event put on by the Simon Wiesenthal Center out of Toronto, their affiliate in Toronto. And Carm's going to, they really want Carm, not me, but they're going to be talking to her about the Holocaust, what's going on in the Middle East, her take on the world, geopolitics, the whole Megillah tomorrow night. So that's why we are doing a noon show tomorrow, 12:30 on Suzanne Simpson, who is a missing mother of four. This stuff never seems to stop happening here in the United States. It's a violent country. That's got to stop. Justice for Dan Markel. Love you, America. Thanks to Joe Patuto, law professor Louis Baptiste, and Stephen Webster, who are partners at law and best of friends. Thank you all for being here. We'll see you tomorrow, 12:30, everybody. Oh, God. 2-0 Dodgers. You just ruined my night, Spaced.